Mr. Finch, are you available on the phone? I don't know what button to push, but we got you set to speak to us on Zoom.
Then did you push that button? I stood up.
He's here present.
Oh, I do. I think I wanted to hear from you. You don't even need the Zoom there, Bill. Is Joe available? I think I see his picture up there. Will y'all hook him up?
Mr. Chairman, can you hear me?
Good morning, Joe.
Good morning, Mr. Chairman. How are you, sir?
We're good. You were sworn in last time when you testified, and I had to leave that meeting early to make an appointment back in Athens. I had just a few follow-up questions for you I wanted to ask, and then I was hopeful you might have had a chance to review some of the legislation that we're looking at this morning.
Yes, sir.
Have you had a chance to look over Senate Bill 604 and 605? And
I have. Yes, sir, Mr. Chairman. I've had a cursory examination of the bills. Our appellate division had court yesterday when I'm the appellate division in our circuit. So I was busy with the child molestation case, but yes, sir, I have looked at those two particular bills, and I'm more than happy to answer your questions I could.
Yeah. So what I wanted to do was just follow up with my line of questioning from our last meeting that I had to kind of cut short. And then I'm going to hear a few more comments from Bill Finch, from the Solicitor Generals, from their views on some things. And then we will start presenting the bills, and you won't be presenting sworn testimony then, but we'll let you, make your comments on those since you're in a position of leadership with the District Attorney Association. Does that suit you all right?
Absolutely, sir.
Okay. We got several areas that we're addressing, and one of them we talked about to some extent was the pay levels for district attorneys. And I think you generally concurred with Madam Bonnie Willis's testimony previously in the committee that in many cases, district attorneys and assistant DAs are underpaid, or it's difficult to get quality attorneys at the pay levels that the state provides. Would you concur with that?
Yes, sir.
Would you just refresh me one more time on how it works? So you said there was a range of pay from, I think it was 72,000 up to 134 or something in that range.
I think it's a little like 135, but yes, Mr. Chairman, that's approximately correct. Starts at around 72 and goes to about 135, depending on levels of experience. Basically, as long as an assistant DA is performing adequately, then I think they basically can go up to a different step increase per year. It's roughly around 2,500, 3,000 as far as a step incrementally every year. But it starts at 72 and goes to about 135.
Okay. Are you finding that you're able to secure good quality attorneys at that pay scale?
That's kind of a difficult question to answer, but I would say that certainly it's helped from last year when you all were kind enough to give us an increase in our base pay for our assistant DAs to 72. We have seen an increase in our resumes overall. But when you look at the starting salary from the University of Georgia, our flagship institution and what they start out at in civil practice, which is in the six figures, it's obviously difficult in any particular economic environment to get quality assistant DAs, but we do the best we can down here, and I'm proud of the staff that we have gotten in our particular office.
And hit me one more time, the number of positions. I understand you have one chief assistant that's funded by the state. And am I correct? There's one assistant per Superior Court judge in your circuit?
Yes,
is
sir,
that it?
Correct.
And then maybe is there some, special domestic violence prosecutor or some other the accountability courts? I think you had mentioned that.
Yes, sir. It's an accountability court, and then also a juvenile prosecutor, because we do a juvenile court in our circuit. Some circuits opt out, but we do juvenile court, so we have a juvenile prosecutor, and then we have a drug prosecutor that does drug prosecutions.
Yeah. And so everybody gets those. I think almost every circuit has an accountability court now. So you would basically get 4 out of the gate, and then 1 per judge, assistant DAs.
Yes, I think that's accurate, Mr. Chairman.
Now, their salaries are paid through the state government, and we funnel it through PAC, correct?
That is correct, sir.
Are you able to supplement their pay if your local circuit governments will give you basically a supplemental pay or other expenses?
Yes, Mr. Chairman, I think that's correct. And I think that's correct statewide, that if the county or any particular counties want to, they can, if they have the discretion and the funds to do so, supplement assistant district attorneys. That's correct.
Okay. And can they fund additional assistant district attorneys, new positions if they are gracious enough to do that?
Yes, sir. Yes, sir. That's absolutely true.
And in those circumstances, is the cost of the additional assistant DAs fully borne by the governments within the circuit?
Yes, Mr. Chairman, that's correct.
And I think that's what you were telling me is sometimes a little bit of a tricky negotiation when you have multiple counties sharing in your supplement. Some are more densely populated than others or wealthier examples.
Yes, Mr. Chairman, I think that's absolutely correct. I mean, in our particular circuit, we don't have any county funded assistant DAs. We just don't have the funds in our circuit.
I don't know that it's in code, but I know in practice anyway, that we have traditionally paid DAs a percentage of the Superior Court judge's pay. And I'm not positive if that was 90% or 95%, but those are numbers that have been explained to me by various people. Do you know how that works?
I know it cursory in the sense that I think that that's been the practice. I don't know that it's a statute. I don't know that it ever was in statute. But yes, I think that there was generally a salary that was based on the percentage before. I'm not sure why or what the reasoning was in the past. I think if you looked at the numbers, that's correct, Mr. Chairman.
Yeah. Well, what I've always understood that to be was that you want to be an equal standing or close to equal standing with the tribunal that you're presenting cases in front of. That if you are paid tiny amounts of money compared to Superior Court judges, I guess every DA would be running for Superior Court judge, and they've already got the gavel on you there, but at least give you more standing to represent the state of Georgia prosecuting various crimes.
Yeah, Mr. Chairman, I think that's an absolute a perfect example of when you have that pay disparity, that you're going to have a lot of DAs that when a judgeship becomes available, even not necessarily even running against a judge, but when they have a vacancy, if you have that huge pay disparity, you're going to have a black hole in the sense of the DAs leaving just to take judicial positions for sure.
Right. And we have a bill that was introduced this week. There's a comparable bill in the House that improves DA pay. And I think that was largely in response to the fact that the Superior Court judges got a pay increase last year and you guys got left out. So it in many ways tracks the way that the judges' pay raises were calculated last year, the Superior Court judges. And I'm going to ask you to take a look at that. And I have Mr. Skandalakis looking at it for me too. He was accumulating some data on the budgets of your various circuits to see kind of where we stand and how much more money would be needed to make sure that the state of Georgia is providing enough resources to prosecute all the crime that we're faced with out there. I'm going to ask you to take a look at that as well over the weekend because of your particular position there as head of the District Attorneys Association, and give me any feedback that you may have. The bill that we introduced varies a little bit from the House in that the House was also triggered on a percentage of federal judge pay. And I took that complicating factor out and just kept it as a percentage of Superior Court judge pay. Because there's some complication in the formulation of what a Superior Court judge is going to be paid. It's going to be a percentage of a federal judge. There's no real specification as to cost of living increases, and it's all subject to appropriation by the General Assembly. So rather than a rigid pay scale, it's going to have some flex to it And I didn't want to get us in a position where theoretically DAs could be making more than Superior Court judges if the General Assembly doesn't fund fully and keep up with inflation with the federal judge level. And it's some concern to me that we allow a complete other level of government to set our pay, indirectly, since we're kind of keying off of that. But I want you to take a look at that and give me your thoughts. We did not put that bill on this agenda for today to give time for some feedback so that we could make any changes or adjustments that were desired by your group. Before I leave that subject, has the DA's Association taken a position on the House bill? I think it's 1028 is the number. Have y'all
Yes, Mr.
taken-
Chairman.
Okay. Are you in favor of that or opposed to that?
No, the association is absolutely in favor of that. In fact, we've worked with the sponsors of the bill for the last several months to come up with that and mirrored the judge's bill, as you noted, Mr. Chairman, and basically felt like that was our best avenue to make sure that pay disparity between the judges and the DAs was handled this year, so that we didn't have a glut of vacancies in the DA's Association across the state. So yes, we're strongly in favor of that bill, and have worked with the sponsors on that.
I have also spoken with the sponsors in formulating our corresponding legislation here in the Senate. And there is some discussion that there's maybe some disparity or some dissension among the DAs, maybe some of the larger population centers that have higher county supplements or maybe not as enthusiastic about it as more of the more rural areas of the state or less densely populated. Has that been worked out or ironed out amongst you all, or there's still varying viewpoints?
I think it'd be fair to couch it as varying viewpoints. I think that overall we've got 51 DAs in the state. Approximately 39-40 of those DAs are in favor. So 80% of the DAs are in favor of this particular legislation. Some of the DAs in the metro areas are not. Not all the DAs in the metro areas. There's some of the DAs in the metro areas that are supportive of it. But yeah.
You just froze on me there for a minute. Let's let the Zoom catch up. All right, you back? You froze for a moment on the screen for us. Are you?
Can you hear me all right?
Yeah, I can hear you now. Okay.
Where do I leave off, Mr. Chairman?
You left off that 39 of the 51 DAs favored, and some even in metro areas did, but there was some dissension.
Yes, sir.
Okay. I want to ask you some questions on Senate Bill 605.
Okay. If you'll just give me one moment to pull that up, sir. Okay, go ahead.
And at this point, I'm going to give an explanation of the bill, and then we just want your input as, on the bill, not sworn testimony, but we're moving beyond that at this point. Okay.
Yes, sir.
All right. And then I'll go back to 604, but 605 is addressed at the behavior and the discipline of district attorneys or solicitor generals. And this is just an amendment to the current Prosecuting Attorneys Qualifications Commission enactments 15, 18, 32. After some of our testimony that we've received here in this committee, there were some complaints that we had some DAs that perhaps were not adequately following the Crime Victims Bill of Rights, notifying victims of court dates, et cetera, those type of things, and letting them know when there were plea deals arranged and that kind of thing. So we wanted to include that in this chapter. In our files for committee members, we have the original version, and then there is a committee substitute. I don't think you have the substitute, but I'm going to explain to you the changes, okay?
Sure.
They're subtle but significant. What we've done is we've added failure to comply with the Crime Victims Bill of Rights as another ground for discipline by the prosecuting attorney's counsel. And we also added failure to comply with our open records laws. We had several DAs that had refused to comply, ended up being sued, and we have appellate decisions now saying that they are subject to the law. We feel like in some of the lack of public confidence in our administration of criminal justice is the lack of transparency, and that gives it. What I changed in the substitute was, instead of saying failure to strictly comply with these statutes, was failure to make reasonable efforts to strictly comply. And I don't remember which DAs now have approached me on this and said, man, sometimes we're trying our best to comply, but maybe an assistant DA drops the ball, or we're overwhelmed with volume of cases and maybe miss it here or there. And so I tried to make it that as long as you're doing your dead level best to comply, that's really all we can expect. I mean, that's different than a knowing or conscious or willful refusal to follow the law. And then we added at line 29, failure to exercise impartiality in prosecutions. And that gets back to having personal motivations for a prosecution, or doing it for political gain, or doing it for personal financial gain. I'll just stop at those three and ask for your feedback. Do you feel those are reasonable requirements for prosecuting attorneys in general, but district attorneys in particular?
So I would say that certainly the language "make reasonable efforts" is more reasonable, as you just said, Mr. Chairman, than strictly. And then as far as impartiality, I think that the concern and the questions I would have with this particular bill, and again, I got this bill last night about 8 after court, and then just now the amendments that you've made, I've just heard for the first time. But the questions and concerns I'd have is I really think that this is going to put more of a burden on the rural or the district attorney's offices maybe in the smaller to the medium size, simply because of the number of staff. Like I said, we had an appellate court yesterday, and I'm our appellate division. We have one victim advocate in each particular circuit and 2 administrators that are given and by statute, whereas some of the Metro DAs have lobbyists and media personnel. I mean, I think that these particular statutes a lot of times are going to adversely impact the smaller or the medium-sized offices, more so even than maybe some of the problems that you're having that you wanted to address with this particular legislation in the bigger circuits. And I also would want to know exactly what the definition of impartiality or make reasonable efforts is. I'm certainly willing to work with the committee and yourself, Mr. Chairman, on this. I would like to have a little bit more knowledge and maybe delve out a little bit more of the details before I was on board with any particular legislation of this nature.
Well, that's one reason I wanted to hear them today, to explain them to you and be able to give you time to give us feedback.
Sure.
The committee is going to meet again on Monday evening at 5 o'clock. And if you could get any suggestions, and you can feel free to call me over the weekend, is fine. Or certainly we'll be here all day Monday. We have a committee day. And I'll be glad to take into account what I'm trying to do here is satisfy public concerns or sort of lack of confidence in the fairness and impartiality of prosecutions, but also do it in a manageable, reasonable way that district attorneys agree is workable. Just from a personal standpoint, these are statutes that are imposed duties on DAs already. So they're the Crime Victims Bill of Rights. It sets forth, victim notifications, et cetera. That's the law. You're required to follow that. Same thing with the open records laws. We're not making up new rules or burdens. We're just giving an enforcement mechanism by letting the Prosecutorial Oversight Commission, Attorneys Qualifications Commission, have a ability to reprimand or sanction or whatever a district attorney that is failing to comply with these laws, or even make reasonable efforts to comply with them. So that's where we're coming from. On the impartiality, I'm wide open to if you have a better definition or way to restrict that, but I think it helps all of us. And part of our dialogue with District Attorney Fonnie Willis was she was removed from a case due to an appearance of impartiality, or was that what they called it? Appearance of impropriety, I think was the phrase, without having strict guidelines that her conduct was, inappropriate. And so we're trying to codify them where we can, and this may not be a final list, but it's certainly, that's our attempt. I'll move on to line 30, failure to strictly comply with the discovery provisions of criminal procedure. Any problem with that, or any thoughts or feedback? Obviously, the concern is if prosecutors withhold relevant or exculpatory evidence, that ruins, that tilts the scale and is universally agreed to be inappropriate conduct, unethical conduct. There are rules there in that criminal procedure code. I just wondered your thoughts if that would be appropriate to include as something that could be conduct that could be reprimanded, sanctioned in some way by the commission.
Sure, Mr. Chairman. I liked your idea, and I've got your contact information. I've got Senator Gooch's contact information. I'm more than happy to speak with you all. Once I speak to the association as a general body as a whole, probably would be best. To answer your question on the failing to strictly comply with the discovery, our particular circuit, we have an open file policy that basically solves that. We give the defense everything. I know that's not the case for every particular circuit. I just think
that is in the Western Circuit as well. So that's what I'm accustomed to, but I understand that's not true everywhere. And
sure. Yes, sir.
So that would be very easy for you to agree to comply with, right?
Absolutely.
Individually.
Yes,
okay.
correct.
If you would kind of run the traps on that to make sure there's no inadvertent undue burden I would be putting on prosecutors here. I think the public expects that prosecutors of any level have an obligation to turn over any exculpatory evidence and any damning evidence so that they can determine what type of plea they may want to enter and prepare for trial.
Yes, sir, Mr. Chairman, absolutely. And my intention is to send out a mass email to our listserv this afternoon on a lot of these issues. And so anything that I can help with, I'm more than happy to, sir.
Okay. The next one on lines 32 is failure to comply with the Georgia Rules of Professional Conduct of the State Bar of Georgia. And for those listening or press here, these are rules and regulations that set out expectations of attorneys. And if you ever hear the phrase of an attorney being disbarred or suspended or whatever, it's for violation of some rule of professional conduct. There's a procedure where anybody can make a complaint to the state bar. It's then investigated. The accused wrongdoing attorney has a chance to present his case and explain his conduct or whatever. And then there's a large range of punishment that the state bar can recommend. The Supreme Court actually oversees this and has authority over all attorneys. In the area of all of us, any attorney, including prosecutors, are subject to these rules of professional conduct. Rule 3.8 is specifically aimed at the responsibilities of a prosecutor. And I've had conversations with Mr. Skandalakis. We're going to give him an opportunity to speak here to this as well, but he provided this to me as something where the prosecutors had essentially proposed this and feel very proud that it is one of the strictest rules against attorney behavior in the country. And so that's why I specifically mentioned Rule 3.8 that gives those special duties. And we'll have those available for the committee to review in detail if need be. I actually have copies in my office that we can provide if they're not in the notebooks. What are your thoughts on that? As including that as something that ought to be subject to oversight? I mean, right now it's just the state bar.
Right.
And that is a very, very lengthy procedure. And I'll just, this is an attempt to allow the commission to use violations of this and determine them in their oversight of prosecuting attorneys. Are you comfortable with this, or is there any hesitation on your part?
I wouldn't say hesitation is the word. I would say that I know we already have an avenue, as the chairman has just said, that we have an avenue already where the state bar can seek sanctions or up to disbarment, and the Supreme Court obviously has done so when prosecutors have not followed 3.8. So I'm not sure that we need to reinvent the wheel if we've already got a system in place where we can do that. But again, that's something that I would want to throw out to the association as a whole. And I agree with Director Scandalakis that I think that Rule 3.8 and special responsibilities as a prosecutor is something that we all that are adhering to it think is important and incredibly important. So that would be my answer to that question, sir.
Okay, we'll wait for your feedback on that. And those were the only additional types of misconduct that we thought made sense to specifically list in the statute that gives the Oversight Commission certain powers. I will say that we have passed in the Senate, I think it's already out of the Senate. If not, it's out of committee for sure. It's in a special action is what it was. So it's an agree, disagree type thing with the House. And I believe that we have agreed with it, and it's about to become law that gives a little bit more investigative powers to the commission, the ability to subpoena documents, but it also codifies some appeal rights for attorneys that have adverse action taken against them by the commission. Up until now, my understanding is there's never even been a hearing held. There have been numerous investigations. The number that sticks in my head was 183, but nobody's actually had a hearing before the commission. But it builds in some procedural due process for prosecutors that if you did have an adverse finding or ruling by the commission, you have the right to contest that and to appeal it. So I'll refer you to that as well, because I believe that is now past the legislature, just awaiting the governor's signature. But it may give you some comfort when you started comparing the state bar procedures versus this commission's. I think it will give you comfort. At this time, I'm going to allow other committee members, since this is it's not a deposition you're giving here, to question you concerning that bill, which is our committee substitute to SB 605. I'll defer first to you, Senator Jones, if you had any questions for Mr. Mulholland.
Mr. Chair, thank you. It's probably more of a comment on, I think that make reasonable efforts, I believe is better language, but I think it still kind of has some definitional issues there. On the issue of impartiality in prosecutions, I would just say that that's always going to be a difficult one to kind of show, in the sense that they are impartial. One of the things I used to always tell people is I got too many files to try to figure out a way to find somebody guilty that didn't do it. I got way too many stuff to do to try to figure out some kind of way to get you. But the defense would never think I'm impartial. I mean, if I'm representing a domestic violence victim, the guy is usually a man, right? He's never going to think that I'm impartial. So I do think that may be unworkable. So if the prosecutors come back and say that may be unworkable, I don't think it's because they're trying to be difficult. I just think it may be, quite frankly, unworkable. But I do like the better language about the reasonable efforts, but I think probably maybe still be some tweaks in there too. But I think the impartiality may be one that is going to be difficult to actually do. That's just my comment on it.
Okay. Did you have any questions? Or that was it? Okay. Senator Gooch or Dolezal, do y'all have any questions?
One question. Mr. Mulholland, would it be
Yes, sir.
possible, after you speak to your district attorneys, could you send us something in writing with any of their concerns, so we would have a chance to look at that before we vote on this bill? I'm assuming.
Absolutely, Senator Gooch. I think that's absolutely reasonable and probably a good idea. And then the more that we can kind of work together on this, I think would be a great thing. Absolutely, sir.
Thank you.
Senator Dolezal?
Good.
All right, no questions there. Oh, I'll move on to the sort of the next subject matter that we had on our list, and that would be Senate Bill 604. I think you were looking for that.
Yes, sir. I've got it pulled up. Yes, sir.
Just a brief summary from me on that is right now the Attorney General has concurrent jurisdiction with the district attorneys on certain type of offenses, namely gang type things, and I think sex trafficking, and there may be a couple of other domestic terrorism that are come to mind. I am hearing from the testimony we've received here that in many times DAs don't feel like they have the adequate resources to prosecute some of these more complicated offenses, or they get backed up, as Senator Jones just said, sometimes overwhelmed with the load. This bill allows the Attorney General to assist DAs in prosecuting certain violent crimes, crimes committed by criminal illegal aliens, and especially fentanyl trafficking. The way I have it designed is that the Attorney General it can either reply or act upon request of a district attorney that needs help and wants some additional manpower, so to speak, or if the Attorney General has an intention or a desire to prosecute, that they would notify the district attorney and give them 90 days to determine whether they wanted to prosecute on their own. So it's sort of a deferred, before you assume concurrent jurisdiction, you defer to the acting district attorney in the district where the crime's been committed. I'd love to have your feedback on there, because I have observed in past committee meetings where we have granted some of this concurrent jurisdiction to district attorneys to attorney generals, that many times district attorneys are kind of protective of their territory, their turf, their districts, and don't get up in my business. And that's what I'm trying to do here, is to be an asset, an assistance when requested, but not step in or have the ability to step in unless, they've pointed out some crime or something that needs to be prosecuted and the district attorney's not taking action. Do you think that makes sense? I just like to hear your feedback, because we're trying to respond to the public's concern of certain, sort of plagues of crime, and that are continuing, and concerns that they're not being aggressively prosecuted. I don't think that's intentional on these type of offenses. It may just be lack of manpower, as you've kind of pointed out.
So, Mr. Chairman, again, this is one I probably would want to defer to the association as a whole. I can say that in my particular circuit, and if there was going to be some legislation, I think the language about the DA can request that the AG come in would certainly be better than the AG would have concurrent jurisdiction on their own. I would liken that to the GBI. The GBI doesn't necessarily come into a case unless we request them. We're a requesting agency like the governor or sheriff. And I think that a requesting agency is saying that the district attorney shall request the AG come in would certainly be probably more amenable to the DAs as a whole than saying that they just automatically have concurrent jurisdiction. And the reason I say that is given any particular case, I think that in my particular circuit, we're a very conservative circuit. I would hate to have an attorney general in the future that could come in and prosecute, say, my law enforcement officers on a use of force case. I think that that's why I'm elected in my particular circuit is because I am conservative and I am pro law enforcement. And I don't know what holds. And I know once these laws are codified, I don't know what holds for the future of our state. And any particular person that would be elected may come in and want to come into my circuit and prosecute cases that perhaps that my circuit in particular didn't feel that needed to be prosecuted or that were. So I think this is one that, again, you're going to have 51 opinions on that. That's my just personal opinion on this particular legislation. Just looking at it again, I got this at 9 o'clock last night. But just looking at it from a cursory point, that would be my perspective.
If there are certain types of offenses that need to be cut out of this, let me know. This is not all offenses. I mean, you can see in it, we break out the type of, basically the drug cases, et cetera, in section 4. And it goes on and lets you know the areas where I think the Attorney General could be of assistance if needed. And maybe there's a way to word it. I didn't know whether 90 days was adequate time. We had some internal debates between the sponsors of the bill. you know, if you wait too long, a case gets stale, and you lose your evidence. And so I was thinking 6 months was probably too long. I thought 30 to 60 days would be too short because the DA would have to go through the indictment process many times. I was trying to land the plane at a length of time that DAs felt like would give them an option to proceed with the prosecution themselves if they could before granting concurrent jurisdiction with the Attorney General. So just when you're talking to them, bounce the time period off of them as well. It may be that 120 days is more appropriate. I don't know the workloads, the backlogs that might be plaguing district attorney's offices, but that's the whole point here is if they can't get to a prosecution within a certain length of time, let's let the Attorney General give them assistance and help do it. I didn't.
One thing, Mr. Chairman, I could say that just looking at the bill logistically, I'm not sure how it would work, simply because when law enforcement agencies make a particular case in my circuit, they provide us the file once it happens, and we're lucky we've got great law enforcement that give us those files fairly quickly. I guess that on every particular offense that's alleged in this bill, they would have to also give a copy of that file to the AG. And so those are just some, again, this is just my thoughts getting this from last night at 8 or 9 o'clock. This certainly would be one that I would want to talk to the association as a whole about, but that would be one of the concerns that I have, or just questions in particular. I guess question's a better answer to that.
Okay. You know, in my mind, one of the cases that came to my mind was the Ahmaud Arbery case down in Brunswick, where there was a lot of criticism of the local DA for not prosecuting in that case. And that was highly publicized, you know, the facts of that. That would be an example to me that if a local DA did not want the Attorney General to be involved, they wouldn't ask him to be. But then if the Attorney General saw it and said, listen, we just had a very racially motivated killing down here that the local prosecutors are not intending to prosecute, that they might give them notice. If you don't want to prosecute this case within 90 days, we may exercise our concurrent jurisdiction to do so. I'm thinking it would be more like those type of high profile cases more than just your run of the mill, unless the local DA is requesting help. But that's just so you'll know my thought processes. And it might be that you want to carve out certain type of offenses. This is not just carte blanche, any kind of crime. It specifies the type of things that I think they need, DAs need help with.
Yes.
Other committee members have questions on this bill. That's SB 604. Okay. One reason we're having this hearing today is to sort of discuss what's in these bills and give you guys time to respond before we try to take any action on them on Monday. So
Yes, sir.
Thanks for your input. And Bill Finch is here in the room and he's listening, and we're going to let you testify next, Bill. So be thinking your responses to the same questions. The next bill we wanted to discuss is Senate Resolution 875, which is actually a constitutional amendment. And this has been discussed for literally decades in Georgia. I know from my sort of review that Roy Barnes, who's been counsel for several witnesses in this case, introduced this same bill when he was a freshman state senator. And it was, and of course, as a Democrat at the time, and it did not pass then. It's come back up several times. The most recent that I recall was Senator Josh McCoon, who's now the party chair for the state Republican Party, had a version that this is very close to. And the idea being certain crimes are more on a state level, particularly state government, and it might be best that somebody elected by the entire state have the ability to prosecute. So this would set up something that is not constitutionally permitted right now, that would be a statewide grand jury, just like another grand jury, 13 to 23 people in there. And I limited in here that it's would not exceed 12 months of service. And we gave provision for the Chief Justice of the Supreme Court to designate a Superior Court judge to act as the presiding judge for each of these grand juries. And basically the Attorney General himself, or whoever he designated to be a legal advisor to that statewide grand jury, would be able to give them advice, et cetera. But this was limited, if you look at lines 29 to 31, investigation, indictment of persons or legal entities for any crime involving voting, elections, or a violation of the election laws of this state and all related crimes. So we have had this, I guess, just a series of issues involving voting, different accusations, different prosecutions of different folks, different, and even the apparently the federal government's involved at this point in some of these. And it seems to me that an issue like that has a statewide impact might be best handled by the Attorney General's office, who's elected by the entire state, rather than leaving that with the various district attorneys. Do you have any thoughts on this? I know in the past, district attorneys are resistant to letting somebody else prosecute cases in their districts.
So I'd answer that kind of the same vein that I've said before. I would like to get some consensus from the association as a whole. I can say that particularly in my circuit, I've handled some election cases for neighboring circuits when they filed a recusal. I've got one right now that I'm dealing with that is a political hot button. That being said, the people of the South Georgia Circuit have elected me to do my job, and I'm going to do it impartially and professionally, regardless of politics. And sometimes that's not easy, but I will say that I think that the problem that I would have with a bill like this is if you look at the demographics of our state as a whole, in this particular prosecution, again, we're a pretty conservative part of the state. If you're getting 23 grand jurors and you're doing so based on all the demographics for the state, there's a good chance that in my particular circuit, you may have a jury pool that's got majority of the citizens from a metro area that may not agree with the same perspective on a case that my area in a rural conservative area would agree with. So, and I think that works both ways. And you're right. I think that the grand jury is kind of made up of the best citizens from our particular area. That's just my first blush is that's the concern I would have, is that just based on population alone, for the state of Georgia, you've got Atlanta that's got more people in it than I think that all the counties south of Macon combined. So that would be my concern is that then you're not reflecting the values and the perspectives of your particular jurisdiction when you get a statewide grand jury to look at any particular case. Again, that's just my cursory opinion looking at this thing from the last couple hours that I've had to review it. But I would certainly want the association to look at it as a whole and make some determinations and to give to the Senate committee as a whole.
Okay, I wanted to give y'all time before we discuss the enabling legislation that would need to go with this. That's found in Senate Bill 607.
Yes, sir. That's what I was looking at, Mr. Chairman. Yes, sir.
Okay, we're looking at just the resolution that would require a constitutional amendment. The 607 would be that enabling legislation. Please give that a close review and let me know of any particular difficulties procedurally with the way we've set this out.
Yes, sir.
When you were referencing people in certain counties, it's not like we would pick a jury from the county in which the Superior Court judge that got designated resided or served or presided. It's more from citizens across the state. So that obviously has some, I don't know if complications is the word, but it's got some logistical issues to make sure that we can do this. And I'd be very interested in getting your feedback on that as well. Any other senators have question on that subject matter? Okay. All right. And I'm sure the committee members are going to need some time to digest everything. There are actually just a few subject matters that are being pursued. One, of course, is DA pay. The other is the implementation of a statewide grand jury system for certain types of crimes, aiming at essentially voting issues, anything from voting irregularities to voter suppression to any type of other type of election interference cases. This might be the way, I think, to do that, where the citizens would be more comfortable that it was not being handled in a political manner, rather just something to protect the sanctity of our voting system. And there may be other areas of public corruption that would be suitable as well. So would like to hear. And then, of course, we've already talked about the guidance for code of conduct, so to speak, for prosecuting attorneys, and also want to take a good look at allowing some concurrent jurisdiction on certain areas for the Attorney General to give assistance to local DAs. Do you have any questions for us or anything on your mind now you want us to look into? There's certain flexibility. This committee is going to meet 2 more times before we set our agenda for what you probably are aware we call crossover day. So we have some time to get it right, and very much welcome your input, or if there's another area that is of concern to the DAs where you feel like we need to address through some type of legislation. Our ears are open, and we're wanting to try to do something that meets the proper balance between the concerns of the public and the prosecuting attorneys in our state, which we greatly appreciate and value.
Thank you, Mr. Chairman. Absolutely.
All right.
Thank you for
If you want, are you able to hear us without, I mean, we may let you just stay on if you want to hear the rest of this conversation, because it might enlighten you.
Yeah, absolutely.
To hear what the
Yes, sir.
solicitors have to say.
Yes, sir.
All
I
right.
absolutely will intend to do so, but thank you.
Okay. Bill Finch, could I get you to come to that witness stand right in front of me? Just rather than the podium. Witness number 2 is one I got a mic lit up on.
Good morning.
You didn't really have an opportunity, I don't think, to testify at our last meeting, did you?
I did not.
Okay. Let me get you to, this is going to be sort of deposition testimony from you first then, and then I'm going to go into your views on the legislation that's pending in the committee, okay?
All right.
You'll raise your right hand. You swear the testimony you'll give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
All right. I asked you to come last week, and we had a meeting that ran long. You were kind enough to be here, and at least you got to hear some of the concerns. I want to ask you the same type of questions on pay for solicitors, solicitor generals, and your assistants. And I think it would help if you'd kind of walk us through how your organization works and what type of crimes solicitors prosecute. You got an ex-solicitor here at the table that is going to know more than the rest of us, but some of us need to be educated. It's been a while for you even. Things may have changed.
All right. I prosecute those cases that the maximum punishment is up to 12 months in jail and up to $1,000 fine on regular misdemeanors. If they're high and aggravated, it can be up to $5,000 and still capped at 12 months in jail. Most of those that actually go to trial are domestic violence cases, vehicular homicide cases, DUIs. Not too many people who get up in arms over a failure to maintain lane ticket.
Okay. Theoretically have the right to a jury trial if they elect to
Correct.
do it. Okay. They may not get a very good plea bargain if they do that, right. You are under the sort of the jurisdiction of the Prosecutorial Oversight Commission. Have you had any problems with that so far? I mean, complaints against solicitors or your assistants can be brought before the commission as well as district attorneys, right?
That's correct.
What's your experience been so far?
None. I don't know. I'm never contacted unless a complaint is made against me or one of my assistants, and none have been so far that I'm aware of.
What is your circuit?
The Bell Forsyth Judicial Circuit.
And how big is your office?
We have 2 state court judges, and we desperately need a third. We are in court 3.5 to 4 plus days out of 5, and it is hard to get ready for the next day if you're in court all day the previous day. And our judges want us to be prepared. And so it's very difficult. but we're making do with what we have right now, but we desperately need that third one.
Now, solicitors are employees of the counties that they work in,
That's correct.
and those are not like these 51 judicial circuits for DAs. They're county specific, right?
Correct. And we are paid by the individual counties.
So there are a number of counties that do not have state courts even established yet.
That's correct.
That's set up by local legislation, so to speak, or I don't know, it might be general legislation, but it has, you're a creature of a statute.
That is
creates
correct.
you. And is there any type of uniform pay, or is it just whatever each county that set up a state court wants to have?
That is correct. Mine is set up to where I make 75% of what the state court judge makes.
So your people would not be included in this district attorney pay bill.
Absolutely not.
Okay. Are you comfortable with that system, the way it works? We've sort of delegated or deferred this to the counties. If they want a state court, they can ask for one, and when they get a law passed, they get it. Then it's their job to fund the judge and the staff and prosecutors as well.
I think that's the way it should be. However, there is a limited portion where we do get funds from the state, and that is for training purposes.
Okay.
And the Prosecuting Attorneys Council covers that.
Okay. What about special type prosecutors for domestic violence or for accountability courts? Is any of that funded through the state?
There are some grants that local jurisdictions get, but it is not for a prosecutor.
Okay.
My prosecutors are paid for by Forsyth County.
Do you get any assistance from the state for a victim advocate?
Ours is, it's not set up the way most are. It's handled through the district attorney's office, and that the victim witness program is directed by the DA. And so funding comes from the state for that. However, they share those victim witness personnel with us.
Okay. You are subject to the same laws, the Victims' Bill of Rights, correct?
Correct.
Okay. Do you have any qualms about complying with that law being under the list of inappropriate behavior that can be sanctioned by the commission?
I'm not opposed to it. I think the language may be something that needs to be tweaked. I mean, obviously, we have a constitutional amendment that was passed significantly by the citizens of the state of Georgia. And so complying with Marcy's law is something that every prosecutor needs to be doing.
And what about open records requests? Do you have difficulty with that or receive those often, or?
I get them from time to time. They aren't particularly difficult to comply with.
Okay. Do you agree then that failure to make reasonable efforts to comply with those is a type of behavior that could be sanctioned by the commission?
I think that is something that we probably need to address to the entire Solicitor General's Association. The difficulty would be in how you define what a reasonable effort is.
Sure.
The devil's always in the details.
You'd rather it be reasonable effort than strict compliance, wouldn't you? That there's kind of like strict
course.
liability where there's no room for
Correct.
excuses or explanations. This at least
is
let you
correct.
say you've attempted to comply. Okay.
Yes.
And I guess it would be the commission that would decide whether you've presented a proper argument that you had made reasonable efforts or not.
Sure.
Well, you should feel pretty comfortable there because that commission's made up almost entirely of other prosecuting attorneys or ex-prosecuting attorneys, that they understand what you deal with. Okay. How about the section about impartiality in prosecutions? I could probably use a little guidance on how to improve that language so that it's not ambiguous to you.
Well, I think I already have an oath of office that I have to swear to each time I'm sworn in with each new term. And it is 15/18/61, and it says, I swear or affirm that I will well, faithfully, and impartially, and without fear, favor, or affection, discharge my duties as Solicitor General of Forsyth County. I
Okay.
don't think we need another statute that says what I already have an oath that I need to
That's not the
comply
purpose
with.
of this, to create another statute. It is to allow the commission to have authority to sanction failure to comply with that oath. Right now, that's not specified as something that is improper behavior by a prosecutor. I mean, when you read our statute on the commission's oversight powers, it doesn't say they have the power to make sure that you have followed that oath. Now, I'm sure the state bar could, but they're not going to really move fast on this. I'm just maybe I ought to refer back to the oath. If it's that broad, then maybe this ought to just say failure to comply with your oath of office. Thoughts? You don't have to give me an answer now. I know you're going to be probably having some discussions with your organization over the weekend to get
Sure.
back with us, but give some thought to that.
I will.
It's not trying to create some new duty or burden. It's not trying to change the underlying law. It's only deciding what types of behavior the commission ought to be able to receive complaints on and make determinations whether those violations occurred. Okay.
Sure.
All right. Other thoughts on that oversight bill, on what's appropriate or not? I don't know that there's hardly any complaints made at the solicitor level. What's been explained to this committee is that a lot of the complaints against DAs are from the people accused of crimes that feel like, woe is me, why are you picking on me? Or you didn't treat me fairly, or you were too harsh on my sentence or whatever. And those are
Sure.
things that I don't think are really within the scope or the intent of us giving oversight over. And I think that may be why a number of them are summarily dismissed, unless there's some evidence that some personal animus was involved in a prosecution or disparate treatment for unexplained reasons. But we'd be interested to know, your experience on that. If it sounds like your office hadn't had any complaints filed with the commission.
I haven't been notified.
Okay. Well, as head of your organization, are you hearing other solicitors complain and say, wow, we're being harassed by these ethics complaints?
I've heard of one, but that is anecdotal. I'm not sure it's appropriate for testimony.
Okay.
The difficulty can be when a defendant then files a complaint against you while an active case is going on. I think he'll file a concurrent motion to recuse me. And if he doesn't, do I have a duty to withdraw myself? Because we're talking about animus towards a defendant. The fact that you have a complaint that's filed against you, I think that is grounds for someone finding that animus exists or the appearance of animosity.
In your office, what percentage of your cases do you prepare a formal accusation for? Is that anything that gets to the arraignment stage? Or, I would imagine in my practice, I see the investigating officer makes an arrest, and then the case gets put in state court if it's a misdemeanor, or if it's a minor traffic offense, maybe to probate court or recorder's court or something like that. Some solicitors, though, are very active in formally drafting accusations, at least before an arraignment. Do you guys do that in your circuit, or do you just defer to the arresting officer?
We're the ones that make that accusation. It's a formal accusation.
And that's presented to the defendant at their arraignment, so they know the specific charge against them, the allegations of wrongdoing.
It is. We give them a copy of the accusation and a list of witnesses at that time.
Okay. And in the misdemeanor world where you operate, you do not have indictments with grand juries or anything like that.
I do not. If
That's-
I want to have time with the grand jury, I have to seek the special permission of my district attorney.
And it would require there to be some accused felony offense before doing that.
No, you can present misdemeanor offenses to the grand jury.
You can. Okay. Do you ever?
I have not. I think that there are a limited number of crimes that ought to be presented there. I think the very first one would probably be a vehicular homicide type of case.
Okay. Now, isn't vehicular homicide a felony?
Well, there's vehicular homicide in the first degree, and then there's vehicular homicide in the second
All
degree.
right, got it. Okay. As we had some conversation on forfeiture funds at our last meeting. Is that anything that a solicitor has access to or control over? Is that purely at the felony level, the DA's office?
It's with the DA's office.
Okay. So you don't have access to any forfeiture funds or ability to expend those or anything like that?
No, sir.
Okay. Do you receive the benefits of any of them
No.
that your counties might receive?
No.
Okay.
It's the DA and the sheriff.
That is all the questions I had for you. I was not able to talk with you last week, and I was really wanting to make sure that we understood essentially our limitations from the state government level as to your compensation. It doesn't sound like that's anything we can help you with. If you're unfortunate enough to be in a cheap county that won't pay you much, then you either take the job or leave it, right? Okay.
I am fortunate to live in Forsyth County.
All right. Any question? Okay. Thank you for being with us.
All right, thank you.
Joe, are you still there? Can I get you back on? Pull him up. Okay.
It changed.
Joe, you been listening to us?
I did, and I didn't have time to put on my suit again. I actually got on my Georgia.
Hey, you got the right logo on there, so now we're gonna do whatever you say.
It's raining outside, and I went outside to grab
Hey,
something real quick. Sorry.
You just let the citizens of Georgia know you're a real regular person and a dog. We love it.
Sorry, sir.
Was just had some thoughts came to my mind when we were talking to Bill Finch here about the pay for your assistants. You mentioned that they have had some increases or whatever, and I know that is paid for, at least those that are designated by the state through PAC. But do we need to look at increasing their pay as well once if we're able to pass this bill to increase DA pay? Is that something we need to put in the code, or is that under your, I don't know for sure if we're doing that.
Yeah, so basically, my understanding of it, and Director Scanalakis can answer a little bit more, but we've asked that the legislature fund an increase for our assistant DAs, which is vitally important, in 3 stages. And stage 1 was last year when I say that you all raised the pay scale to 72,000. But I think that yes, we have 3 different stages that we've asked the legislature to increase the compensation for our assistant DAs that's vitally needed. Yes, sir.
Is that in code already that we're stepping it up along the way, or do we need to address it to get it commensurate with what a DA's increase in pay is?
No, we absolutely need to increase it, and it's not in statute. It's something that it's basically a 3-year plan that we looked at and was trying to accomplish over the 3 years.
So is this something just subject to appropriations of the General Assembly?
Yes, sir.
So it might make more sense for you to codify it. It may not, but I want your thoughts on that, because as we go through with this, I'm just going to call it prosecutor pay bill. If you think that's something we need to do, let us know. And the other thing is, I was sitting here thinking when we were discussing my proposal that the Attorney General be allowed to essentially assist or step in and help local DAs where they had manpower shortages, was to know whether you think you got enough manpower. You know, we have this pretty strict formula from the state as to the number of assistant DAs that we will fund. Do you think that's enough, or do you think you need 2 assistant DAs per judge, or maybe another floating one in your circuit, or whatever? I'm receptive to your concerns if you can help us think that through. You got thoughts on that?
Mr. Chairman, I'll take as much help as I can get.
Yeah.
I don't think there's any question, and I think that's the answer that you would get from every DA across the state. You know, we're all overworked and overburdened, and we don't do this to make a bunch of money. We do it because we believe in public service, just like you all do,
Yeah.
and why you're serving. So yes, absolutely would love more help.
Well, I just, I don't have a good feel on the caseloads statewide, how much they vary. You know, it almost seems like in the urban areas with the large populations, they also have a huge number of Superior Court judges. I mean, I think Fulton, I think, has 18 right now, and they're asking for another. And then they got a ton of state court judges too. We've got a piece of local legislation in dealing with Gwinnett County to add a state court judge there, and they already have 10 or 12 state court judges and 10 or 12 Superior Court. Now, I'm not saying they don't need 50, but it seems like as we add judges, it's based upon caseload. That's how they get to the top of the list to add another judge to show that they are overworked or they got too many cases. So once we add that Superior Court judge, we are effectively also adding another assistant district attorney, an investigator, or whatever all goes along with it. Now, maybe that formula works as is and doesn't need to be messed with, but if it's giving too few prosecutors per circuit, you know, basically per judge, try to let me know. I don't know that our state is so, you know, homogeneous that the caseload is going to be the same in every county. But some of those DA circuits, and especially in South Georgia, are multiple counties where they're having to juggle their caseloads. The solicitors are one county only, so it makes their life a little, maybe not simpler, but more concise, more finite. But give me your thoughts if you think we're not providing state funding for enough assistant DAs to prosecute.
Yeah, Mr. Chairman, and I can comment and just touch on that very briefly. Is you know, we got another judgeship, so we had 2 judges, now we have 3 in the last couple of years, and but we don't get an additional. We get an additional assistant DA, but we don't get an additional investigator or victim advocate because we get another judge. Whereas a lot of the metro circuits, I know that for every judge they have, and of course this is county appropriated, but for every judge they have, or they get an additional one, they always assign not only an assistant DA that they get through the state, but they go ahead and get an investigator or a victim advocate that they put in their county budget to assist that assistant DA with that judge. We don't have that luxury, obviously, statewide. So that's certainly something that I think would be welcome throughout the state of Georgia. Absolutely.
Okay. Other members have questions. When I brought Joe back up, we all good? Okay.
Thorough job.
Thank you. All right.
Thank you, Mr. Chairman, and thank you to the committee.
I got one more person I want to testify, Mr. Pete Scandalakis. If you, it wasn't, we're not going to swear you in and take any sworn testimony. I just want your, well, he's so helpful. I just wanted your thoughts on some of these bills. And I thought I would start, we'll just go in chronological order. 604 is the one about the concurrent jurisdiction. Have you given that any thought, or is that beyond the scope of your job?
Yeah, well, I think I need to make a distinction about Prosecuting Attorneys Council, the DA's Association, the Solicitor General's Association. The Prosecuting Attorneys Council is made up of 9 elected prosecutors, 6 district attorneys, 3 solicitor generals, Republican and Democrat. We're nonpartisan. My position is executive director is to reflect what the Prosecuting Attorneys Council does. When it comes to legislation, we will help legislators, Democrats and Republicans, work on language in those bills. However, we work with the DA's Association and the Solicitors Association to represent their interests when they ask us to.
Yeah.
So I don't feel comfortable commenting on these bills at this time until I've had an opportunity to talk to the associations and see what they would like us to do.
Okay. You would defer then to the members, the 9 members of the council.
Of the council. And when the council gives me direction, if the council wants to take a position on a certain bill, they'll let me know and we'll take that position. But most of the time, the council stays neutral. I've been a prosecutor for 40 years. I've been an elected prosecutor 25 with the PAC council since 2018. In all those years, I can only think of 2 or 3 bills where the council has said, you know, tell the legislators that this is the council's position on these specific bills.
Yeah.
Other than that, I can't think of a lot of instances.
You're a statutory creature,
Yes, sir.
not an individual, but the organization.
Yes, sir.
Okay. And does the statute give you this, make you be the funnel for state funds that go to district attorneys?
So, yes, sir. We're the fiscal agent for state paid prosecutors.
Okay.
So any state paid position, we go to House Appropriations, Senate Appropriations, submit the budgets. And then when those budgets are approved, we're the ones that get those positions, fund those positions and make sure those individuals are paid.
Okay. When you talk to them about this sort of suite of legislation,
Oh, yes, sir. I'm typically what we do. We also have, as y'all know, many of you know Robert Smith, PAC legal counsel. Robert tries to watch all the bills y'all are dropping during the legislative session. Anything that touches on criminal justice or district attorney's pay or anything of that nature, we try to get those bills out to them as soon as possible and seek input from them. When there's testimony needed in front of commissions such as yours, the chair will reach out to me and say, Pete, I need somebody here on behalf of the DA's Association. I'll talk to Mr. Mulholland. I'll talk to Mr. Finch or whoever happens to be the president at the time and say, we need some DAs up here. We need some solicitor generals up here.
can you give me a shortcut to the code section that establishes PAC and deems you the fiscal agent, or are those multiple code sections?
I don't have it off the top of my head, but I'll be glad to email it to you.
Just save me spending time on legal research. I
Yeah.
appreciate that. And did you accumulate that data on the pay, on the different pay budget levels for pay on the different 51?
Yes, sir. We didn't do all 51, but we did send you a sampling of small circuits, middle circuits, and large circuits. So that was emailed to your staff and you yesterday
Okay, great.
by my chief financial officer.
Thank you. Mr. Leader, any questions from you? Any other members have questions?
Let me just finish.
Yeah.
But not only
Yeah,
are we a
thanks, Seth.
fiscal agent,
Yeah.
we're also in charge of training prosecutors. We're also have what we call resource prosecutors up there. You were asking about domestic violence. We have a grant prosecutor who is very skilled in domestic violence. When other circuits need help, she's there to assist them. Sometimes we handle conflict cases. So we also do all that type of work too. And I'll send you the statute.
So you have prosecutors that work for PAC that are available to assist?
Available to assist and train. They do a lot of training, but on occasions they do get assigned conflict cases and they go into circuits and prosecute cases.
Okay, if there's some type of internal conflict?
There can be a conflict where the DA or the Solicitor General has recused himself in his office
Okay.
or her office. If that's the case, I have 4 conflict prosecutors that travel the state and can take on conflict cases. Right now in 2020, I think it was 2025, we got about 500 conflict cases that came through PAC and we assigned those out. We took 56% of those cases to try to take the burden off the DAs and the solicitors because of their caseload.
And if you don't use a conflict prosecutor, do you search for another district attorney to assist in a different circuit?
We do that. So, for example, we look for surrounding circuits. If someone conflicts out of the Chattahoochee Judicial Circuit, we look around that neighborhood to see, can we get a DA to take that case? And sometimes after we've exhausted the DAs, in other words, we've given them a number of conflict cases, I'll assign it to my conflict team.
Okay. So back to the election interference cases then, is that how that came about once DA Willis was disqualified from the case, that would have disqualified her entire office.
That's correct. Once a DA or Solicitor General is disqualified, the entire office is disqualified.
And at that time, then you have a choice. Your conflict attorneys can take over that prosecution, or you search out other district attorneys or solicitors, depending on the level of the crime, that might be able to.
Yes, sir.
assist.
Correct.
And that's just solely in your discretion?
Yes, sir.
So you could pick somebody in, Valdosta to prosecute an Atlanta case, or somebody in Raven County if they were willing to do it.
That's right. The law allows me to appoint. However, I found that you just can't appoint someone who's not willing to take the case because
Right.
it doesn't serve the public well. So I'll make a telephone call and say, Chairman Calvert, I got this case. Do you want to take it? And if you say, heck no, Pete, I'm not going to take it, I say yes, and I go on to the next person.
And under that circumstance, are they compensated for that? Or it's just they get their same DA pay that they get whether they're prosecuting in their own county or helping somebody out?
They get the same DA pay. If you're state paid, you get the same pay regardless of where you go. Now, we do compensate you for travel and for other expenses, meals and things of that nature, but that's all you get. Now, if I have to go get a private lawyer, I am restricted with state funds what I can pay. I can only pay the hourly rate of a DA. The hourly rate of a DA in Georgia is $66 or $65.66. I'll have to send that to you.
That'd be good. So they derive that by figuring what their salary is and dividing by some
Right.
number of hours. That's a reasonable
Right.
workload, I presume.
And Mr. Chairman and Mr. Jones, I can tell y'all, you can't find a private attorney for $65 an hour. And it's just,
Okay.
not to mention, from that $65 per hour, that has to cover any administrative fees, your secretary, if you want to get an investigator, if you need expert witnesses, that's supposed to cover all that. And so that's impossible.
It's the same administration. Great.
In a couple of these cases, I'm just going to use Burt Jones cases as an example. You personally kind of reviewed that or took control of that?
I did,
prosecution?
yes, sir.
When you do that, do you get paid anything more than just your salary?
My salary.
So you're kind of the stopgap there if you can't find anybody else to look at it. Okay.
Yes, sir.
Do you have the option to just on your own assume a case before first looking for a conflict attorney?
Yes, sir.
Okay.
The law that, if you will recall, prior to 2021, the Attorney General did all the appointments. DA recused, sent a letter to the Attorney General. He would appoint someone. In 2021 or 2022, I'm getting the years mixed up, legislature changed that to the Prosecuting Attorneys Council. The law allows me to appoint either a DA, a Solicitor General, the Attorney General's office, or someone from my office, or a private lawyer.
So on the Ahmaud Arbery case, tell us how that played out. The local prosecutor got removed from the case for some reason. I can't remember all the ethical situation, but
So no, sir. What happened in the Ahmaud Arbery case, and I'm very familiar with that. What happened in Ahmaud Arbery, and this is prior to Prosecuting Attorneys Council having the ability to
Okay.
appoint. So this was when it rested with the Attorney General's office. What happened in the Ahmaud Arbery case is when that incident occurred, the DA at that time, Jackie Johnson, recused her office,
okay,
and it was sent to another DA in a local jurisdiction
by the Attorney General
by the
under the prior law.
By the Attorney General. That's correct. And that prosecutor reviewed the case and determined, he eventually ended up recusing himself, but before he did, he wrote a letter saying that he didn't see a crime there. I respectfully disagreed with that at the time, but I had no input on that. And then the Attorney General came in and appointed Tom Durden, a neighboring circuit. Tom's office was a very small office, and he did not have the ability to do it, to handle that size case with the publicity it was getting. He recused his office from it, and A.G. Carr appointed the Cobb County DA, Joyette her last name slips me right now.
Mhm.
Yeah, she's now with the Board of Pardons and Paroles and the Cobb County Office prosecuted that
Prosecuted that.
case.
And if another event like that happened today, same scenario, it would fall to you.
Yes, sir.
Head back to find somebody as a conflict attorney to take over, else deal
Yes,
with it
sir.
yourself.
Correct.
Which approach do you think is best? Sounds like we just loaded you up with the new responsibilities at that time.
Well,
Back in 21 anyway.
I think having it with the prosecuting attorneys council, who has a closer relationship with the DAs and solicitors, and also understands the volume of cases is the better approach. Now, whether or not it's being adequately funded, that's something that, we can talk about, with the appropriations and with Senator Tillery and Chairman Hatchett, Chairman Tillery and Chairman Hatchett. But I will say, you talk about assistant DAs, Georgia's a state of 11 million. There are only 429 state-paid ADAs in this entire state.
429.
Yeah, 429, maybe 430, somewhere around there, 432, for a state of 11 million people. All the other assistant DAs are funded by the counties. And what Mr. Mulholland said is absolutely correct. It doesn't matter if you are DeKalb County or if you're the smallest circuit. You get one per judge plus the others, and then you get one investigator, one victim advocate, and 2 admins. So you can be a county of 1 million people and the formula is the same. 2 admins to handle the entire thing, 1 victim advocate. And we've had these conversations before. The perfect model, if you could fund this model, would be that you have 2 ADAs per judge, 1 investigator, 1 victim advocate, and an admin person. So to handle the courtrooms, to handle the volume, because prosecuting cases, just like defending cases, is labor intensive. You need a prosecutor on one side that can look at the file and make a decision. You need a defense attorney on the other side so you can negotiate cases. When you don't have sufficient number of people, you get bottlenecks. And that's what happens. And the criminal justice system, all of these DAs, all of these solicitors have absolutely more than they can handle right now.
How many assistant DAs funded by counties?
We do not have that figure.
Can you find it?
I can survey the counties and see if I can get a response to that survey. Some DAs are real good about answering surveys, some are not.
It would be very helpful to them if they want additional employees to respond.
I will make it a
So
job.
we can, if we were going to change that formula, this would be a possible vehicle to do that, the bill that I presented on DA pay. That would make a lot of sense, because if there are some counties that are sharing more than their fair burden of hiring prosecutors, just because they happen to be larger population districts, I guess it's 51 districts, so not always a county, but some of those districts are single county, right?
Yes, sir.
Yeah, like Fulton County.
Yes, sir.
I think, you have this kind of a yin and yang that I'm seeing. You have some of the rural counties saying, we don't have the access to local assistance, let's call it county supplementation. So we don't have enough manpower, enough help. And then you got some of the large counties saying, hey, we got 1 million people in this county and we're limited to however many number of assistant DAs and we don't have enough resources. They're both sort of arguing. And I think that's part of the divide on the DA pay thing too, is the rural areas versus the more urban areas is the way it seems to be breaking down, but it might be a solution somewhere where other than just being rigidly by judges and hoping we're providing enough superior court judges per circuit, that we look at population or caseloads. I don't know, but now's a real good time for them to weigh in. And if they will help give us the data, we can make an educated decision. And better than anybody the legislative process. You've been here as long as I have, watching it all evolve. And there are lots of opportunities for us to work together. This committee can change the bill that comes out. It can be amended on the floor of the Senate. And then when it gets over to the House, they can, I mean, there's just a whole lot of places to tweak it and perfect it as before it becomes law. And in my opinion, the earlier the better to get something working. If they have a workable solution or proposal that is financially possible for us, please let me know. Leader Jones, do you have questions? Okay.
Yeah.
My Vice Chairman, Senator Dolezal, do you got any?
I do.
All right, you're recognized.
Thank you, Mr. Scanalax. Appreciate you being here. I do want to say hello to Bill Finch in the back as well. He does a great job for Forsyth County, and thanks for taking the time to be with us 2 weeks in a row. You were here last week when we heard testimony around the use of forfeiture funds.
Yes, sir.
And I want to restate what I heard, and I want you to tell me if my understanding is correct, and I have a question. Forfeiture funds, state forfeiture funds can be used to hire personnel, but they must be used to hire personnel at the state scale.
That is how we interpret it. Yes, sir.
And the $68 that you just mentioned for the assistant DAs is kind of the number that we landed on as the cap in our dialogue last week with the person that was testifying. And I think that that's derived from the $138,000 salary or something in that range. I'm using rough numbers here. It's my understanding as well that there's a report that the DAs provide to the state auditor as it relates to the use of their forfeiture funds, and then there can be a complaint filed by the state auditor if they find a problem. Obviously, Mr. Wade, we know from the invoices, was paid $250 an hour by DA Willis. We also know that according to the receipts from Fulton County, and we have seen documents in this committee that show that the forfeiture funds were used to pay some of those $250 an hour invoices. Assuming that the fact pattern that I just told you is true, what other avenues do we have besides the state auditor digging through these reports and breaking down hourly rates and seeing what hourly rates were? Is there any, now that this has been established, does this committee have the ability to do anything? Does the general public have the ability to do anything? What steps are available to people that may want to file a complaint about these forfeiture funds?
So, Vice Chairman Dolezal, one of the problems answering a question like that, it depends how the DA is working with his or her county. For example, some counties, when the DA gets that 10%, and very few of them, once you have a seizure and you sell the property, and let's say it's cash, 90% goes to the seizing law enforcement agency, 10% goes to the DA's office. And then we have, as Mr. Bergman told you, our best practices guide. Depending on what relationship that DA has with the county. For example, some DAs allow the county to keep that 10%, that 10% fund. And then when they need that money for services, they simply request the county. And I don't know if the county has put it in the general fund and then pays out of it. So it's kind of difficult to answer that question without knowing the specifics of how it's set up.
Why would that? I'm confused why that should be relevant.
Let me take, for example, when I was DA, I had 5 counties. So I kept the forfeiture funds in separate accounts so we could accommodate, so we could count it, keep it accounting of it. But I was also aware that there was one county that the 10% funds never went to the DA. Once that 10% funds was forfeited, it was forfeited to the particular county. When he needed money, he would simply make a request to the county, I need money for this. Well, once the 10% goes to the county, it can go into the general fund. If it goes into the general fund, it's really not limited how the county's going to give it back. So that's what I'm trying to, and maybe I haven't made that.
Okay. So in a scenario where there are separate funds for the forfeiture funds, and you can see clear delineation on payment vouchers between payments made from the general fund and payments made from forfeiture funds, if I, as John Q. Public, can look and very clearly see that forfeiture funds were used to pay someone a number that is over the $68 an hour by a multiple of 300%. What are the options of accountability there?
The options would be to follow what the statute sets forth as you go to the Attorney General and you make that complaint, and the Attorney General can ask the state auditor to look at it and then go from there.
Okay, so there's nothing through PAC that would flow, that
No,
would
sir.
all
I'd-
flow through the Attorney General?
I see where you're getting. I have no authority because I work for the DAs and I am here to assist the DAs. I have no authority to discipline the DAs or to do any of that.
Okay, and what about the Oversight Commission?
The Oversight Commission, I'm not familiar with all their rules. They may have the ability to do that. I don't know.
Okay, so the straight line would be to the Attorney General, and anyone can refer something like that to the Attorney General, or does that need to be? Okay,
I believe so.
thank you, Mr. Chairman.
The forfeiture statute allows the money to just all from forfeitures to go directly to the county budget, the general.
No,
fund.
it doesn't allow it, but you can do that. 10% goes to the DA's office, but some DAs like to set it aside and just give it to the county and let the county give it back when they can,
So that
when they need it.
sounds like a way for the DA to circumvent the limitations of the uses of those funds.
Well, I think
If
it's
they
a,
keep it for themselves, then we have specified what they can spend it for. If they give it to the county, it can be kicked back to them and used for all kind of things.
well, I think it's a win-win because, for example, the DA may not use all the asset forfeiture funds, and it may build goodwill between the DA and the county, saying, you know, I'm forfeiting these funds. The county's getting them. I won't always need them, but I may need an expert witness for something. And so this expert witness may be, I don't know, $10, $15, $20,000. Don't need them all the time. Just, you know, pay for this expert witness. It's hard for me to answer that without being specific. And I have to have, I don't know the accounting practices of Fulton County. And so I don't want to speculate. I don't know the accounting practices of DA Mulholland Circuit. So I don't want to speculate on that. I do know how I did it when I was DA. And what we did is state funds, you had state funds and federal funds. We considered forfeited funds that came in to us as state funds, and we followed the state statute.
You kept that money separate account.
Kept it separate from our federal funds.
Yeah.
And then, of course, anytime the statute changed, you had to make sure, when did these funds come in? Because when the statutes changed, there were things you couldn't do before that you could do later. And so we had to make sure that we were doing that correctly.
So it's not like the funds would lapse and like a state budget or something. And if you didn't spend it in the year, it goes back to the county or the state.
That's correct, sir.
You could build up your fund.
They accumulate.
Okay. Well, if I were DA, I'd build up my own fund and I'd have to go begging to the county. I mean, it'd be, give you.
You could do that, but
flexibility.
there's nothing that other than the county can't look at your asset forfeiture funds until they exceed a certain percentage and say, we're no longer going to help you with your office. I might add that asset forfeiture funds, not all the counties are awash in asset forfeiture funds, you know, and as asset forfeiture, for example, it used to be when I first started as DA, if you were running drugs, you drove some fancy cars. I
Right.
mean, you drove, and so when we were seizing cars on the interstate and they were paid off and you could prove that they were used for the purpose of running drugs, you'd take that car, sell it. 90% of that fund would go to the sheriff, 10% to the DA's office. Well, it didn't take long for drug dealers to figure out, we're not going to drive fancy cars anymore. We're going to drive old beaters and, you know, put drugs in them then. So, you know, it kind of changes. And when we talk about asset forfeiture funds, it's easier to talk to a committee about the low-hanging fruit without really getting into some of the more complex investigations, some of the more complex asset forfeiture funds that DAs do take on and do seize. And then remember, the state provides $0 for operating a DA's office. The statute says that operating costs for a DA's office, everything from purchasing a copier to a vehicle, to paper for assistant DAs, it comes from the county, paying the electricity, everything. And some counties are better off than others, and DAs use some asset forfeiture funds to run their offices.
All righty. Having no more questions, we thank you all for being here. And thank you as well, Mr. Mulholland. If you're still listening to us, you may be out on the track by now. If the rain stopped, but we will be adjourned. We'll meet again at 5 o'clock on Monday. So any input any of you may have on ways to improve the legislation before this committee, please provide it to me or other committee members. Thank you.
Thank you.
Thank you, Mr. Chairman.